Good afternoon, my lady.
Good afternoon, Mr. Chairman.
We take and subscribe to the oath. I must apologize for keeping you waiting in excess of an hour. It was due to some circumstances beyond our control. So, accept. I will then ask the clerk to administer the oath.
I hereby administer the oath. I, Janapare Adzua Bartels-Kodwo, do in the name
of the Almighty God,
swear
that the evidence I shall give before this committee touching the matter in issue
shall be the truth.
Very well. In 2 minutes, just tell us about your background.
Very well, Honorable Chair. I was born some 63 and a half years ago in Tamale, in the Volta region, precisely on 20th November, 1961. I am, due to my father being an education officer and I being on transfer, well, he being on transfer, and we having to move from time to time. I entered Achimota School in 1973 and did my GCE O-levels in 1978. I followed up with my GCA certificate in St. Monica's Secondary School, Ashanti Mampo, and finished in 1980. In the same year, I entered the University of Cape Coast, where, due to the universities being closed down in those times, I finished in 1985 instead of 84. And then I did my national service with the Department of English of the same university for 2 years, finishing in 1987. Thereafter, I gained employment with the Ghana Education Service and was posted to my alma mater to teach. I taught there for a period of 8 years, and during that period, I found time to learn to become a lawyer. I finally left the teaching field in about 19. The VAT service was absorbed into the legal department of the then IRS. So I was there briefly. I was always desirous of joining the bench. So I applied, and I was taken in as a magistrate in November of 1997. I was a magistrate till 2004, and then became a circuit court judge, went on till 2010, and became a court of appeal judge. Became a high court judge, and then went on to the court of appeal in I'm mixing up the dates a bit, if I may just refer.
We have all those things on your
Very
CV.
well. I mean, from the High Court, I went to the Court of Appeal December 2019, and I've been there since this moment. So briefly, that's something about me.
Thank you very much. We've delayed you, so we don't intend to delay you further. We move straight ahead to call for questions. So, Honorable Tampuli, you have the floor.
Thank you, Mr. Chairman. My lady, you are welcome, and I congratulate you on your nomination. I have one question for you. I may come with a follow-up, but depending on how you answer. But I want us to look at Article 33.5 of the 1992 Constitution. The rights, duties, declarations, and guarantees relating to the fundamental human rights and freedoms specifically mentioned in this chapter shall not be regarded as excluding others not specifically mentioned which are considered to be inherent in the democracy. With this provision at the back of your mind, would you consider that LGBTQ rights can be captured under the Ghanaian law by extension, by extending it to Article 33.5? Thank you, Malik.
Thank you, Mr. Chairman. At this moment in time, I am of the view that the Supreme Court has pronounced on matters relating to the LGBT. Readily, I cannot remember those cases. There are about 3 of them. One of them, I believe, people.
Thank you very much. Any follow-up?
Thank you, Mr. Chairman. So apart from these LGBTQ, do you conceive of any rights that can come under this provision, under Article 33.5, from your practice and your, everyday relationship with people?
At the moment, no.
Very well, that will be it, Mr. Chairman.
Honorable Bafo. Ewa.
Thank you, Mr. Chairman. Congratulations, my lady, and welcome to the committee. My lady, in 1981, the intestate succession law was passed to protect mainly widows. That was the philosophy. Their right to the property and also surviving children. In our local parlance, we refer to them as, colloquially, we refer to them as orphans. Patrick is not, Honorable Baba is not ready to look at it as a law mainly for women. Thank you very much, my brother. But I'm looking at protection for women, widows, and their children. Beyond establishing matrimonial courts and specialized courts to ensure speedy resolution of disputes over the estates of deceased persons in the interest of widows and their surviving children. What can you think of by way of recommendation to Parliament that we should do to ensure expeditious justice for widows and their surviving children?
Yes, my lady, before you answer the question, we are enjoined to be gender neutral. So wherever a widow and children is referred to, particularly widow, let's use the appropriate phraseology, spouse. So you may proceed to answer the question.
Thank you, Mr. Chairman. Your question, if I understood, is what Parliament could do to speed up resolving matters in coming out with the laws. The matters come to court, and I think, apart from probably interpreting them to the hilt, the judges or courts also bring in some judicial activism to protect those who are on the weak side of the law, if I may put it that way. Therefore, in terms of Parliament doing something further, I do not think they can do more than come out with laws. Maybe some of the problems that have to do with the settlement of estates are cultural issues in terms of perhaps, even though PNDC Law 111 is there, some people think that even though the law says this, I think that this person shouldn't have that. So beyond the promulgation of laws, I do not see how much further Parliament can go. That is my view.
Thank you very much. Any follow-up question?
My lady, so from your answer, Parliament has done its bit. There will be limited procedural bottlenecks, more or less speedy delivery of justice for such people. What can the court do? If there are procedural reforms you may want to recommend to ensure that such people get justice expeditiously, given the consequence of lengthy litigation on the properties and even the persons themselves, to the extent that some of them, their education is affected, their well-being affected. I mean, their lives.
Yes, my lady, you have the floor.
Thank you, Mr. Chairman. Very well. I believe that you are interested in how fast cases or matters to do with administration of estates are settled. I believe the Judicial Service has put in place courts that deal with matters of probate issues. On the other hand, I have been in courts, even at a time in the Court of Appeal, something came on appeal to do with a matter of estate. And as we say in the Children's Act, children cannot wait, or even if not in the Children's Act. Since I was a magistrate, it was always one of mine. So things come up, maybe somebody's school fees are outstanding, something is hot and burning. The courts find ways of dealing with it. I do not think estate matters wait unnecessarily long, unless, of course, there are some contentious estate issues which may go on for a while. But generally, I think the courts do their best. Thank you.
Well, I will give the floor to Honorable, is it Asamoah? Boama, Honorable Boama. You are entitled to one question and a follow-up.
Thank you very much, Mr. Chairman.
Not Yao Boama, but Boama Nyako.
I'm also Yao Boama.
You're also Yao Boama.
But Isaac against Patrick.
Okay, then
Thank you very
Yao Boama, the first time.
Yes, Chairman. Thank you very much, Chair, and congratulations, my lady, for your nomination. There's been a lot of discussion around the workload at the Supreme Court, which is leading to the increase in justices at that level. Now, we know the jurisdiction of the Supreme Court from its original to appellate and supervisory. There's a conversation around limiting the jurisdiction of the Supreme Court to its matters. What is your view in terms of limiting the role or the functions of the Supreme Court to other matters and capping some cases at the Court of Appeal level? Thank you very much.
Very well. Thank you, Mr. Chairman. I am aware, or I realize that the load at the Supreme Court has gone or grown bigger with the years. Yes, it will be good if some cases terminate, let me put it that way, at the Court of Appeal, so that the Supreme Court will have maybe less load in that sense. I do not know whether that satisfies your question, or that's all of the question you asked. I think there was two in one. I didn't quite.
Chairman, thank you.
And
Yes, you concur that it is possible to do a cap of or limit the jurisdiction of the Supreme Court to an extent. But in your reasonable contemplation, from all the jurisdictions that we've raised, which one do you think comes in handy, taking off the burden at the level of the Supreme Court, knowing that you are coming from the Court of Appeal and have risen through the ranks from magistrate up to the Court of Appeal now to Supreme Court?
I'm of the view that some of the appellate load should be taken off. Maybe cases that begin perhaps in the magistrate courts could terminate at the Court of Appeal, and that will be it. Thank you.
yes, I will give the floor to Honorable Anthony Mia.
I'm very grateful, Mr. Chairman. Welcome, my lady, and congratulations on your nomination. Accra. Right, okay, let's start with the legal aid. My first question would come from the legal aid. In your contemplation, Do you think that the Legal Aid Commission has successfully implemented Act 977, which established the legal aid? Again, do you also think that in the case of the vulnerable and the marginalized, that the legal aid has succeeded in addressing their concerns for legal aid?
Thank you, Mr. Chairman. I would not say that they have not succeeded. Rome certainly was not built in a day. The legal aid has its own issues in terms of funding, in terms of enough lawyers, and other peculiarities. And besides, I don't know how well spread they are in the regions, whether they are represented everywhere, and how many lawyers are manning it. So in terms of helping the vulnerable, there are many more people that need legal aid than the country has legal aid to offer. Thank you.
Thank you. Follow-up question. If you have the opportunity to make recommendations to help the legal aid properly achieve its mandate of serving the poor, what are some of the recommendations you would make?
Thank you, Mr. Chairman. One thing that comes readily to mind in terms of manning or staffing the legal aid, I would say that for fresh lawyers from school, they could be made to do their national service right across the country in legal aid offices, maybe a certain minimum number posted, or depending on the size of the region. And the point is, if we can serve national service, and the next time they finish, another batch goes, and I think we'll build the capacity and we'll be achieving what they are set out to do. Some may even stay on and make their lives in legal aid. Thank you.
Now, my second question. Would you support a constitutional amendment barring the appointment or nomination of persons perceived to be politically exposed to the Superior Court of Judicature?
Did I hear say, will I support, Mr. Chairman? Can he just, the question said, will I support the question?
You see,
If you just repeat it kindly.
in the recent past, okay, a school of thought has held the view that certain persons, I would give examples, persons who have held positions as regional chairman, constituency chairman, etc., of political parties. For instance, it could even be a former minister of state. All these persons are described as persons that are politically exposed. Would you recommend that the Constitution is amended so that these persons are barred? Exactly, from joining the...
Very well. In other words, the Constitution is silent on that now. I believe that if we are to go that route, the country has to have a conversation about it. I do not believe that I am enough here to give an opinion on that. Thank you.
Please, your third question.
Thank you. So my follow-up question then. Now, let us zoom into Article 1284.
My brother, that cannot be a follow-up question.
It's directly related. It's directly related to appointments.
It's directly related to...
On the qualification of judges to be nominated to the Court of...
That would be a different question, because your earlier question was on anybody who has a political color. Can such a person be given the opportunity to go to the... listen to me, to go to the Supreme Court?
Exactly.
And she said, we can have a conversation on it.
Exactly.
But she's not here to offer opinion
Mr. Chairman,
on that matter.
Both questions fall or come under 128, under qualification of persons to be nominated to the Supreme Court?
Well, ask the question and let me see.
Very well. My lady, my follow-up question is, many perceive judicial promotions, nominations, etc., to the apex court as politicized. Okay. What transparent mechanisms would you recommend to ensure that merit-based progression is introduced within the judiciary?
Well, before allowing my lady to answer the question, take note that that is your question number 3.
Very well. Your good self expressed the view that many perceive. From where I come from, I've been in the service for 28 years. I have worked from as young as being a magistrate, and at every time I believe that I have worked hard, and by dint of hard work, I am where. I use myself as a good example. I was promoted to the Court of Appeal in 2019 by the other administration, and like a thunderbolt, minding my own business, I am here by the grace of God. Thank you.
I'm very grateful. That will be all for the nominee.
Thank you very much, Honorable Member. I'll proceed to give the floor to Honorable Alikpili Makoroko.
Thank you, Chairman. Congratulations, my Lord. I'm always excited to see women get to this position. In fact, you're a role model, and then we are all learning from you. Just a quick one. How does the law deal with properties owned by couples in divorce or death?
Very well. I believe this House has still yet to pass the law on spousal property rights. But in the courts, anytime the courts have been challenged with the properties belonging to spouses, they have dealt with them in an equitable manner. I do not think the law is that just because you are a spouse, you are entitled to anything. You will be dealt with according to the law, and every case will be looked at on its own merit. It's either if you worked hard, if it is one person who went to take a loan, or if it was agreement that I'll acquire my own property whilst I was married to you and you acquire yours. So at the end of the day, the law would always be fair and equitable in dealing with spousal property. That is what I can say.
A follow-up question. We know outside Ghana, they practice child support. I don't know if there's one existing in Ghana. If not, are you considering it? Thank you.
Thank you, Mr. Chairman. I do not believe it is in my place as a nominee for the Supreme Court to consider spousal support. If we want to enact a law as a people, the debate would have to go out here on this floor, and at the end of the day, those who make the laws will make them. Thank you.
Mr. Chair, thank you so much. I'm wishing you all the best.
It's now the turn of Alhaji Omar.
Thank you, Chairman. Ladyship, congratulations. I have one single question that I've been asking, and that has to do with separation, the doctrine of separation of powers. What is your...
A path for all the arms of government, and ordinarily everybody is in their lane, the executive, the legislature, judiciary. In parliament here, you have your own laws. You carry on with your lives like everybody else does. But then, that won't mean that if something is done which is repugnant to the Constitution, under which we all are shaded, those who are responsible for taking a say on it will not. For example, if a matter comes to court, which has to do with Parliament or executive not doing what they're supposed to do under the Parliament, I don't think the judiciary will sit down and just fold its hand. That does not mean that it will be encroaching on your rights or your work. But that is how good governance works ultimately for the common good. So, thank you.
Any further question?
Yes, a follow-up. Thank you. Practical, that a few years ago, Parliament was working on a law, and it had not yet come to conclusion because it has to be signed into law, then we go for interpretation or challenge it. But it looks as if the Supreme Court, not once, severally, interfered in the work of Parliament. I want to find out, if you are sitting there, will you continue that?
Well, are you talking in respect of the decision of the Supreme Court in Adzua versus Attorney General? Adzua versus the Attorney General? Well,
And the president had not yet.
then with all due respect, I'm likely to overrule you because the nominee is not here to comment on a matter pending before the court or a matter that the court has already made pronouncement. So you may ask another question.
Thank you, as I guided. Thank you. I wish you well.
Thank you. I will proceed to give the floor to Honorable Patrick Yaobuama.
And then congratulations, my lady. My lady, I think with your experience, you've read a lot about Chapter 6 of our Constitution on the directive principles of state policy. My lady, please, are you there? Especially Article 36. On economic freedoms and rights, and the fact that the president must, within 2 years, bring to Parliament his plan of development and what have you, asking for direct investment to come into the country. There's been a debate on the bench for some time about the justiciability of this chapter. I want to hear your views on whether the provisions of under Chapter 6 are justiciable, in your view, because I'm sure some of your colleagues have their own ways of merging these provisions with other statutory provisions to make it enforceable. So I just want your take on this. Thank you.
If I understood you, Mr. Chairman, you mean whether the provisions under Chapter 6 are justiciable. I am of the view that if they were not, the framers of the Constitution wouldn't have even put it there. At the end of the day, the whole country is entitled to development. As a people, we have brought up this law for ourselves, and we have carved a path which we wish to follow. And I believe we also have a national development planning body. So at the end of the day, if we follow the trail, we would achieve or would arrive at where we would want to. So in my view, it is. Thank you.
Really, that would be difficult, in my view. Because if you look at some of the provisions,
We'll get there. Rome was never built in a day.
Very well, very well. I just wanted your thoughts because I've read certain positions by Justice Datebai and his group and how the positions some of them took. That's why I asked you. So I know you've taken an Uber before. Very well. You've heard about Airbnb. I'm sure you've stayed in one of them.
Not yet.
Not yet. Yango and all the new technologies that you don't even know the source, but you pay with your card and enjoy the facilities. You are there 2 minutes, a car comes up, you don't know the person, you key in your address, the person takes you, whether the person is a murderer or not. You just sit in the car, takes you there, you travel and you book an Airbnb and you go and stay there. With some of these evolving technologies, would you recommend to your JTI, Judicial Training Institute, to take a critical look at some of these emerging trends so that the justices are abreast or kept abreast with some of these modern trends so that they will be able to determine some of these issues when they come to them in the nearest future? There is a decision in Italy. That's why I'm asking you this question. Thank you.
Very well, Mr. Chair. You've mentioned a lot of business names that all form part of this modern trend. But your question, if I understand you, saying that the JTI should train judges so when some of these things come up, do you mean when issues, if you could clarify that kindly?
Thank you. That these are emerging trends and new decisions are being taken in some other jurisdictions. I haven't heard of any in our country. So I just want to find out from you whether it will be part of your activism or your advocacy when you go for training so that we are not caught off guard when some of these things come up. It's that simple.
Very well, Mr. Chairman. I share the view with you that these are modern and new trends, and we all have to learn, especially the judges, because the society is ever evolving and these things will catch up. I would give you a simple example about Facebook. Some years back, when I was in the circuit court, I think, I know there's something that is called porn revenge or nude revenge. Porn revenge or nude revenge between exes, like ex-partners. So, girlfriend, let me say, we are all adults here, a nude picture of his former girlfriend with other people, and you know how the world is. I always tell friends that once you take the first photo, click, it's no longer yours the moment you send it. And you can imagine the mental agony to this person, but the matter came to court and it was difficult to apprehend, but with our electronic laws, et cetera, and I think the police also did some good investigation and he was apprehended and dealt with. So we have to learn about these things all the time. And sometimes, like you said, it's not just the Uber. You go to San Francisco, the cars come with no driver and we still sit in them and go.
Thank you very much, my lady. As for me, when the car comes and nobody is in it, I will not sit inside. I'll run away. No, we just go and observe the bridge and run away. My lady, let's stay there and talk about media freedoms. The Constitution guarantees media freedoms, but there's little to talk about when it comes to content. People generate content, share them, discuss them, before you realize everything is out there. But they will tell you, oh, the press is not subject to any direction or control. Yes, but there are limitations within the media space anyway. Do you think as a country and as Parliament, we haven't done so much with regards to regulations to ensure that the media is kept within bounds and within the Constitution so that our image as a country and as individuals are well protected and respected within the media space. Because a judge will wake up in the morning and find his or her picture on the front page on a matter that he or she has sat on. You wouldn't know where that journalist or media house got the judge's photograph, but it will be there. And maybe even the ruling that the judge gave is not well reported, it's skewed in a way. Those are things that I believe do worry some of you as justices of the court. So I just want to hear from you on some of the things I've spoken about. Thank you.
Very well. Ghana is a strong advocate for media freedom. Going back some years back, maybe 30, 40 years ago, I do not believe that the media landscape was what it is today. And perhaps that has propelled us into a kind of media free-for-all, if I may put it that way, like you are saying. So some of these things happen, and of course, we get disturbed. Others go to court seeking for their reliefs. However, I do not think that we have to go out right away with the big stick, knocking everybody. Maybe we first of all have to engage the media. Their responsibilities, their freedoms have to go with responsibilities. They have to know that. We have to sensitize them. People have to learn how to report. Even like you mentioned about a case being reported. We have a judicial media persons, I believe, but sometimes they don't report exactly. But I think it's a lay. Maybe we can have some further regulations that will make the media or the journalists realize that the fact that he has a microphone or the fact that there's ink in his barrel or pen or the fact that he has a keyboard that has an enter stroke does not mean that he can just go to town.
You advise or you have a training program for them, those who report from the courts. Would you ask that your next budget you request for some more money? I can see the acting CJ here for some training of the journalists who report from the courts. Would you? And I wish you the very best, my lady. Thank you.
I believe that can be done in collaboration with the JTI, and if it's brought to the attention of the Office of the Acting CJ, that certainly can be arranged. Thank you.
So you're asking for more money?
No, I didn't talk about money. I just said they could be trained. But of course, if we got more money, we would not be any less miserable.
Thank you.
Honorable Patrick Yaoboma, you can donate 40% of your bank account to them. It will be in the right direction.
I wish I could do that, but, you know, I'm miserable.
It's now the turn of Honorable Haji Aladi Ayamba.
Thank you, Chairman. Congratulations, my sister. I'm so proud to see you seated there. As a woman, it's not easy. I know you've worked hard, so I continue to pray that your efforts would send you higher. Well done. I wouldn't have asked you any question, but if I don't, I know what some of, I won't say that one. My sister, there is a problem on the Criminal and Other Offences Act. I asked earlier on, and I think this is my third time of asking this same question. There is a gap when it comes to the age of having sex and the age of marriage. And it's quite disturbing. For me as a woman, I have looked at it severally, and I think that if at 16 years, especially the girl child, is still in school or supposed to be in school, and she is allowed or permitted by law to have sex, I believe she could easily become pregnant, get infected, run away, elope and leave school and what have you. Or even she could be misused. Excuse my language, I'm a teacher by profession, so I'm not derogating any teachers, even those who are teaching her. Now she has been given the permission. It means that even if that happens, nobody can be held responsible. She can become pregnant, that ends everything. But then, she cannot get married to the one who has impregnated her because she is still 16 years. Because the law says that 18 years before she can get married. The gap between 16 and 18 is a very big problem. 2 years is not a small thing. The child would have started even running around if she becomes pregnant, but she is not married. How do we reconcile this issue? My question is, how are we going to make sure that the girl either shouldn't have sex when she is 16 because of all these things we have identified, or the girl can marry? I'm referring to the girl mostly because I've seen that the issues are mostly on the girl child. Or she should wait until when she's 18. What do we do as women to help them, whether the girl or the boy?
Very well, Mr. Chairman. If my memory serves me right, I think this gap was even bigger when I was a junior judge. It was probably 14 something, if I remember. I may be wrong, but it was bigger. See, sometimes it is very difficult to legislate issues that border on morality. If somebody can have sex at 16 but cannot marry, levels. I believe when you say, what can we do as women, you didn't say, what can you do as lawmakers? But I can say, what can we do as women, sisters, mothers? I think education is a natural contraceptive. The longer the girl child stays in school, the longer it will get to the point of settling down to have a family. It doesn't mean that, I'm not saying that everybody should go to school and become a judge or a doctor or a lawyer or something, but even if a girl child grows up to become a young lady, has to do some training to learn cookery or sewing, all those are training times, and they keep you rooted and focused. So that is one of the things that can be done. But if we move the gap and we even make it 18-21, I am sure we'll come back and have the same conversation. So you cannot keep on legislating. There are other ways, like I've mentioned, that this problem can be solved. And then education should go out there to families, to our brothers, our uncles, our teachers, our grand-uncles, that we must leave the girl child to grow up and become the woman that...
Thank you, Chairman. When I started asking this question, I want us to all know how hear from us. I want to just say, no, we don't want them to be apprentices. But then, that's on a lighter note. Let me thank you very much for coming up with a suggestion that is on the issue of not having lawyers and what have you in the hinterlands, especially our villages. You made a very good suggestion, and I believe that we've all heard it, and I wish that if Parliament could even take it up and make sure that it is enacted into law to ensure that lawyers who come out should be posted out there, but with support, with some kind of support to encourage them. They should have accommodation, travel allowances, fringe benefits to make sure that they actually go and practice. I believe that it will encourage others. And I think that you made that point. It made my day. So thank you very much. And then I wish you all the best. I pray that you continue to rise. Inshallah. Thank you.
Thank you.
Thank you very much. I will proceed to give the floor to Honorable Kweku Rickett Hagan.
Thank you very much, Mr. Chairman. And my ladyship, congratulations. I have perused your CV like everyone has. And actually like the idea that you went to St. Monica's. It's a school that I know very well because
Honorable members, order. We can call for further and better particulars after the vetting.
Actually, every auntie, cousin, including my mother, went to St. Monica's in Ashanti Mampo. So that's all. Yeah. But on a serious note, I have a question here which I asked the previous nominee. And it's, I said in Ghana, even though we have district courts which are supposed to deal expeditiously with matters, but it looks as if our court processes are still very, very slow. And I wanted to pick your mind on this, that if we think we need to set up some small claim courts to deal with matters that borders around, let's say, 10,000 Ghana cedis, that can be dealt with, small courts, that can deal with such matters very quickly, instead of keeping the law process longer and longer. Just want your view on that.
Very well. If you are just talking about small claims courts, I believe that the courts as we have them now, they have the space for those small claims. And setting up more and more courts, in my view, respectfully, will not solve the problem of cases moving fast. Thank you.
I'll just end with this. I did another, it's also something that I'm curious about, and that is to do with, I did ask this question earlier, I think it was yesterday, that most of the courts that I have seen, and not, thank God, not many, you go there and then the atmosphere doesn't look that conducive. You have, either there are no ACs present, or if they are there, they are not working. But I still see, I mean, I've been accused of that. I still see, you know, our lawyers and judges in their wigs and gowns that are actually, look, they are suffering, really heated. I know this is a colonial legacy that we institutions like yours, you know, guard very well. But don't you think it's a bit outmoded? And we should start maybe designing something that is much more practical to our climate, and that will make our lawyers and judges feel comfortable. Like our speakers, I know there are only 3 of them in Parliament now, have taken their gowns off and put on the attire that Mr. Speaker here, my chairman, is wearing. And maybe do with the gowns and wigs on ceremonial occasions. This is on a very light note, my concern for lawyers and judges. Thank you.
Very well. Like you said, it's on a light note. Old habits die hard. The spots of leopards never go. The surgeon is in his scrub. The policeman is in his dark uniform in the hot sun. So I do not think that the judges are so upset, or the lawyers, about it. But if we have to, it's a conversation that we should have. Those, and at the end of the day, if we think so, it will happen. Thank you.
You see,
okay, sorry.
Honorable Rickett Hagan, the lawyers love the wig and gun. But the non-lawyers are rather worried about the wig and gun. Because of this, anytime I'm going to preside, I will wear the gun.
My ladyship, congratulations once again, and I wish you well. Thank you, Mr. Chairman.
Thank you so much. I will proceed to give the floor to Honorable Jerry Ahmed Shaib.
Thank you very much, Mr. Chair. My lady, you are welcome, and congratulations to you. My lady, so you are known to be honest. You're also known to be friendly, industrious, ambitious, and you're a grammarian. You're a grammarian. I mean, you're somebody who has very good skills in writing grammar. That's a report I read. I just want to find out how you came by all of this.
Mr. Chairman, thank you. Well, I say fortunately, my parents were both into education. My mother was a teacher. I followed her to class 1. I started reading early, writing early, went through school, and ended up reading English for my first degree in literature, and taught it for about 8 years. So maybe that is the explanation. Thank you.
On the issue of you being honest and having practiced for about 3 decades, as having been on the bench for about 3 decades, from the district court to the circuit court to the high court, the appellate court, now, I mean to the appeals court, now to the Supreme Court. Have you at any time in point been approached by someone to offer you some sort of gift, bribe? And what was your posture? What did you do about it?
Maybe 25, 26 years ago, maybe I can't remember totally, but when we started as young magistrates, sometimes you go to a court and you have to develop a certain posture because people watch you and then people come and try and play tricks with you. But the moment you also send them the body language that you're not here to play monkey games with them, that's the end. So I wouldn't say directly somebody has come to, but we live with people, people get to know you. Integrity is everything. What you do in the daylight and what you do in the night, they are the same. So I wouldn't say that somebody has walked up to me or gone through somebody directly to come to me. Thank you.
So my second question. So having still been here for about 30 years, what recommendations would you make in reference to judicial reforms and why?
When you talk respectfully, Mr. Chairman, judicial reforms, will that mean to do with the actual courts and administratively?
They are all encompassing.
Very well. To do with judicial reforms, many or oftentimes people complain about the slow pace of trials or court work. I won't say that. I will say that the judicial service I entered 28 years ago is not the same as today. For example, the lower courts, I don't think I ever saw a recording equipment in my court. We wrote laboriously. But times have changed. To have great reforms, we need to put in the infrastructure. If we talk about even e-justice, e-justice does not operate on steam, for lack of a better word. We need to put in the network. And many times, we find that a lot of things, we keep them in Accra for lack of finance to expand. So for judicial reforms, they should be across country. If we talk about cases moving fast, efficient, speedy trials, it shouldn't happen in only maybe the law court complex. It must happen across the nation. That means that there must be massive injection of funds. So judicial reform does not come cheap. That's the first thing. We need massive injection of funds if we want to run an e-justice system. For example, 2 years ago, I happened to visit Kenya, and we went to their judicial training school, referring to e-justice and what they were doing there. And they even said, they came much after us. Ghana started e-justice some years back. They really came on board when COVID caught up with them. And at a point, their Supreme Court even sat serious. The World Bank was with them, yes. So if we want to reform drastically, we have to take some of these things, the bull by the horn, and do them. Otherwise, we'll be tackling them piecemeal, piecemeal, piecemeal. That is one. For reforms, capacity building of judges. You can't train a judge maybe at entry point and say that is it. It must be continuous education. We must have good libraries. Law books are expensive. Not many people. We are entitled to a book allowance. That comes when it comes. For sure, it comes, but when it comes. And I am sure the book allowance will not buy too many books. So, fair enough, if we can't buy too many books individually, we must have a well-stocked library where judges can go and have reference. Otherwise, we have to pay for these online libraries, even if it can be done for maybe the service and everybody can access it. Those are some of the things that will equip the judges to give off their best. Immediately, those are the two I can think of. Thank you.
Thank you, milady. Milady, I picked up the e-justice part that I'm more excited about. If you had your way, what exactly would you recommend that we execute in reference to e-justice?
Very well.
For instance, I mean, can we say that judges should be taken through a whole educational program on AI and all of that, and even the service of REIT and all of that? Are we looking at any new ways of doing so?
E-justice is a complete package. It's not new to the judicial service. It is there, but it is being applied maybe to a limited extent. So I do not think that it is something new that judges have to go and learn. We build upon it as we go on. And talking about AI, I mean, AI has come, but that is not the immediate need of judges to deliver judgments. Already in the Western world, even with AI, lawyers are summing up and writing addresses for the bench, and some of the things that they bring from AI are completely, as we say in these parts, non-fact. So it's not a matter of AI. E-justice is where the things that we do in the physical world. Why should somebody sitting in Tamale who wants to sue somebody in Accra travel, whether by air or by bus, to come and file a writ in the registry? This can be done online. Evidence can be directly taken. Those are the things we are talking about. A judgment, even rulings. Why should people travel all the way somewhere to go for a ruling? They can be delivered online, etc., etc. Even with the criminal justice, talking about bail and 48 hours, etc., etc. I am of the view, the law says people should not be kept more than 48 hours. The police will arrest them anyway. They will arrest them maybe on a Friday. Don't keep them for 48 hours. The courts will only open on Mondays. For example, we could have a weekend court, but it does not mean that the court has to sit physically on weekends, like the housemen and the residents do in the Ministry of Health. If you know you are the judge on duty for the magistrate level this weekend, you know it. So between the hours of 4 p.m. and 7 p.m., we are running an online court for people who have been kept 48 hours across. We can work out the modalities, but these are little things we could do to help the cause of improving the judiciary on the whole. Thank you.
Thank you, milady. Milady, this will be my last question. Milady, same reforms. and in particular, I'm looking at the criminal jurisprudence or criminal justice system. Our prisons are choked. The prisoners get pittances. Sometimes feeding is even a problem. I mean, I don't know the exact amount now, but the last time the Minister of Interior was here, he admitted that the amounts per prisoner or the monies per prisoner is very inadequate. Do you generally have any suggestions with reference to the criminal justice systems, and if there are any reviews you recommend, please?
Thank you, Mr. Chairman. I am of the view that the time has come when we should strongly advocate for non-custodial sentences in relation to minor crimes. We will have to define what we mean by those minor crimes, but that's a way to go. We see them. Judges, we used to go around. I mean, we see them on TV. We've seen them physically. Why shouldn't they also have rights? We could build 1 or 2 more prisons to decongest. They are entitled to sleep like we sleep, not just be all squashed up like sardines. So, in my view, non-custodial sentences, and maybe a new prison or two, maybe one built in the middle of the country further up, one built somewhere. That is a way of decongesting the old prisons. Thank you.
Lady, so this is just a follow-up. Yes, still the prisoners. Are we considering caning people when they do wrong? Maybe once in a while you openly give them some lashings. Maybe somebody stole Honorable Patrick Baumer's phone, and no. It's just as part of the non-custodial ways of dealing with criminals. Can we suggest that caning should be proposed, and that when someone goes to steal a phone or yam or an olunka of gari, and you can tell that this person is famished, and that's the reason why the person got. Can we cane those people? Is that a suggestion you?
Well, it's now the turn of the available leader, deputy leader. Are you also taking the place of the leader? Very well.
Thank you very much. Congratulations, my lady. We are all equally happy that in the scheme of things, gender equity has been considered. And it is my belief that is the more reason why we have the 7 nominees. We have 2 strong ladies within the 7 nominees that have been appointed by the president. And I believe that, yes, there are people who believe that the affirmative action law, which has been passed, relates more to competency than just the promotion of women into any position. I believe that competency is a critical need. That from our patriarchal nature as a country, we have issues with the women participation in leadership and in governance. And therefore, it is critical that this affirmative action law is enacted. I would like to tease out from you, what will you do to promote this law? considering the fact that we have a number of people within the judiciary who may be up for the right appointment, but because they have not reached the the qualification, that's what I would say, the qualification back, it has not been possible to promote them to the level which you have reached at the moment, but to enhance the participation of women in the judiciary. Thank you.
Thank you, Honorable Chair. I'm not saying that we have enough women in the judiciary, but we have many women in the judiciary. Currently, if you look at our annual report book, the ratio, the men are about 50 point something, and we are about 49. They are just about 1% and a little more than us. In the past years, maybe 20 years down the road, backwards, a lot was done for the girl child. I am a woman, but I do not believe in affirmative action for just put anywhere for any house sake, and they go and they don't perform. You and who gets the flag? It is we, the women. I believe in mentoring young girls, bringing them up, building capacity, encouraging them to gain the heights. I would say, apart from the grace of God, nobody has plucked me from anywhere and put me anywhere ever in my life. All the steps of my life, I have worked hard, bid my time, waited on the Lord if need be, and at the end of the day, I am here. So in the judiciary, we have quite a number of good women, like I said, the skills, and like Honorable I just said, very soon, it might be that there may be more. Maybe at this point, I may become a boy child advocate if I'm not careful.
A follow-up. It's very interesting to mention that very soon you become a boy child advocate. And if I can get your sense well, it's all because of the kind of insecurity that our current male, the male youth are finding themselves, because they feel that we emphasize too much on their on the female. But it is important that we bring every female into speed on this particular issue. We are never saying, and I need to underscore that we are never saying that promote any woman at all. Competencies are a critical need that will require the promotion of every woman. But what I wanted from you is that, what are you going to do specifically? Unless maybe you are telling me that you don't want to promote women into the positions in which you have been able to, because nobody nurtured you. But that is what I wanted. You've named education as one aspect. There are also mentoring that you can also be looking at any point in time. I don't know. There are so many people who feel that in talking about affirmative action, it means you are a feminist, and they put all kind of negativity to it.
Honorable Leader,
and
what
I
is the
feel
question?
that is not the case. So we are only creating awareness for all people to note that it is important that we get the women into the society, because women also do well in whatever they do. But what I believe must be done at this point in time, for which maybe we will require your proposal, is what constitutional provision can we make at this point in time to take good cognizance of the affirmative action act that we've promoted out there. Thank you.
Sorry if you understood me by saying that affirmative action, as I understood it, meant that women should just be promoted for promotion's sake. I did not mean that. I said, if that were to be the case, and the woman didn't perform, we the women would not be happy. But asking me that what constitutional provision, I am of the view that women and men in Ghana have equal rights. I mean, we all start out at school. We are all encouraged to be the best of ourselves, gain the highest. In my little space, I have young lawyers, some of whom I've encouraged, who have become magistrates and circuit judges now. Others who are in law school, who are passed through my hands during internship, and I mentor them. At the end of the day, in my little space, those are some of the ways. And also, going back to the girl child, we encourage girls to stay in school. Education, 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 education. Because education, in my personal view, did a lot for me. So that is what I have.
Thank you very much. My lady, could you share some personal or professional obstacles you have faced on your journey to become a justice of the court, and how your story might inspire the next generation of legal minds? Thank you.
Very well. Our work can be laborious, lonely, frustrating, and what have you. I mean, sometimes I look back when this nomination came and I just wonder whether this is me, because sometimes you have to sit up night after night after night to read, and you never finish reading. Those were obstacles. Even sometimes to go to work. There was a time I worked in Tema, but there was no official accommodation in Tema. And I was not, there was no official accommodation in Tema, and I lived on the far edge of town, towards the West Hills Mall. I had no choice, and at that time, the N1 was under construction. I had to go daily, go at dawn. Sometimes you leave the house and the moon is still shining, and you have to cross Accra. The N1 was under construction. You have to go around Pambrose, Dansuma, Independence Avenue, come back to Tetekwashi before you go on. I mean, I went through all that. There were very frustrating moments, and going to tell my coming every day you're on the motorway and all that. But resilience, I mean, tough times build resilience. That's what I'll say. So even though you have sleepless nights, you want to do what everybody's doing, you can't. You have to be very disciplined as a judge. Those are all obstacles. Maybe you want to go and sit somewhere, but you cannot go and sit at +233. You have to sit behind your books. And all your mates, like all my mates are retired now, and then you see all the wonderful things they can do and get up to, but you cannot. But at the end of the day, we are here and we are thankful to God.
Thank you very much, Mr. Chair. My lady, I think we are teasing this issue out of almost everybody here. What do you think of Article 66? First, if you may open and then get it read out.
Mr. Chairman, did I hear her say I should read it out? Very well.
And share your views with
Very well.
us.
Term of office of president. A person elected as president shall, subject to clause 3 of this article, hold office for a term of 4 years, beginning from the date on which he is sworn in as president. A person shall not be elected to hold office as president of Ghana for more than 2 terms. The office of president shall become vacant on the expiration of the period specified in clause 1 of this article, or B, if the incumbent dies or resigns from office or ceases to hold office under Article 69 of this Constitution. 4, the president may by writing signed by him and addressed to the Speaker of Parliament resign from his office as president. Thank you. Please, what was the follow-up question? What did I think of it? I think it's crystal clear. The Constitution, the president cannot hold office for more than 2 terms, and that is it, period.
There's no ambiguity about it.
As far as I'm concerned, or I can see, I do
Yeah.
not find any such ambiguity.
Anyway. Yes. And I'd like to find out from you, there is the common belief that the judiciary, critics have held the judiciary as corrupt. But I would like you to share with us what you think about corruption in this respect.
Corruption anywhere should be eschewed, not only in the judiciary, but anywhere. I am of the view that when people talk about the judiciary, a lot of times they clamp up or gather up everybody working in the judicial space. It's not only judges who make up judicial work, right through from other services, the police, the prisons, judicial staff, judiciary, they all work together. So I do not think it is a blame to be laid at only the foot of the judiciary. However, one bad fruit in a basket makes all others bad. So I am humbly of the view that any presence or otherwise of corruption should be stringently seen to and wiped out. That is what I have to say. Thank you.
Thank you. Yes. Okay. Well, my last question, my lady, that is, how do you balance respect for local cultural norms against international human rights obligations? Thank you.
Very well, Mr. Chairman. Did I hear you say, how do we balance local cultural norms against international human rights obligations? I would say that, if I understood you, I would say that whatever is not culturally repugnant to us and is intellectually right, we'll marry the two and work with it. Thank you.
Thank you very much. I proceed to give the floor to Honorable Togbi Osahin Alexander Kwamina Aponyo Maki. You have the floor.
Thank you. My lady, please, let us look at page 1 of your CV, your 5-page CV. Okay. Lady, you said at J, biodata personal profile. At J, you say you speak every English entry.
Yes, Mr. Chairman.
Your tree, out of 10, 9 out of 10, 1 out of 10, 2 out of 10.
7
How
out
would
of
you
10.
rate your
7
tree?
out of 10.
Oh, okay. Which of the trees you mean? The Ashanti tree or the Kriapim tree? Or your own standard tree?
Received tree.
Which one?
Received tree.
My lady, which one is that?
as I heard it being spoken around me, and I picked up.
You come from Peki?
Yes, Mr. Chairman.
And you were born in Tamale?
Yes,
Servants or public servants who
yes,
found
my
their
father
way.
was an education officer. He traveled the breadth and length of this country.
In your family, are you the only woman or a couple of?
My siblings, we are 3 females and 2 males.
Are you the oldest or the youngest?
I'm in the middle.
Is the male older than you or younger?
Respectfully, Mr. Chairman, one is older, one is younger.
From the records, you were in Achimota School, and then you moved to St. Monica's Secondary School in Ashanti Mampong. So you had an experience of a mixed school and same-sex school.
Yes,
growing
Honorable
up.
Chair.
Are you able to share with us any experience in both situations, please?
Very well. I spent 5 years in a mixed school, so I was used to that. And then I found myself in a girls' school for 2 years, but I survived. Thank you, Mr. Chair.
My lady, proud to your joining the bench. You indicated you worked with the GRA.
Yes, Honorable Chair.
Where exactly were you at GRA? Were you at the...
At the time, I joined as Honorable Chair, humbly Honorable Chair, at the time, I joined the Value-Added Tax Service when it had just been introduced. Then within a few months, it was annulled. Therefore, the staff there in the legal department were absorbed into the Internal Revenue Service as it was then known. So in those days when I was there was nothing like GRA as we know it now. Thank you.
From the records also, you would agree with me that you spent some 9 years at the High Court.
Yes, Mr. Chairman.
Until you were eventually promoted in December of 2019 to the Court of Appeal. You also spent 6 years, 2004 to 2010, Circuit Court, but you don't indicate where you were
I was
transferred.
in the, respectfully, Mr. Chair, I was in the Cocoa Affairs Court. I spent the time there in Accra.
Have you been a High Court judge in Winning? I want to be sure. Did a certiorari application that was brought before you regarding some actions of the University of Education that came up for question, and you listened patiently. One of the things I learned from you, your level of patience. You listened to everybody, lengthy submissions, and gave your ruling that they were acting within jurisdiction. And you even encouraged that the decision be tested at the Supreme Court, which was something very unusual, because I've had the occasion of practicing before judges at the High Court. When they give their ruling, they say, go and certiorari me, go and certiorari me. And they just embarrass you, the lawyer, as if it's a personal fight. But you said, look, it would be good to test the law, so go and test it. And in fact, after going to the Supreme Court and back, you inquired to know the outcome. Though your decision was set aside, you were not at all worried. Now, in your determination of matters that involve state institutions, by way of judicial philosophy, are you likely always to look at state interests as your first option? Are you likely to look at state interests as your first option in terms of arriving at a decision? Are you a pro-state person?
Respectfully, I always pay fidelity to the law, so I will not say that I am a state person. Whatever comes before me, I'll look at the facts and look at the law, and I will be guided.
Our lady, you know that many lawyers have difficulty in open court practice. Sometimes when we meet as lawyers and we ask some of our colleagues, why have you stopped going to the court, or why don't you want to do court practice? The complaints are that some judges are too harsh. Not that they don't like to be corrected. That is the lawyers. Not that they don't want to be corrected. But their utterances. And the emphasis is that some female judges are not kind at all regarding their words, and some are very emotional. I have really experienced that myself. What would you say to encourage some of these young lawyers who have such concerns about such attitudes of judges, particularly female judges?
Mr. Chairman, I will say that it's unfortunate that people will want to stop their whole practice because of, again, it would be unfortunate if a judge or a female judge were to speak harshly or berate a lawyer, be it a junior or whatever. I do not think that has been my cup of tea. I have not behaved that way on the bench. I would not encourage it. If I were to meet any lawyer who says he has stopped practice before that, I will encourage that person to go back and pick up the pieces and practice, and not to be deterred by such.
Quite encouraging. Thank you very much. My lady, I'm going to take you through some few questions. These border on constitutional principle of equality before the law, especially in the context of calls for equal parental leave rights for men, paternity leave. And my main aim on this set of questions basically is to explore your understanding of gender equality and social justice reasoning. So I shall proceed with the first of these set of questions, respectfully. 1, on constitutional interpretation of Article 17. Article 17 of the Constitution guarantees equality before the law and prohibits discrimination on the basis of gender. Do you think the absence of paternity leave in Ghanaian law constitutes gender discrimination against men?
Honorable Chair, thank you. To the extent that the men are denied it, that is some form of discrimination.
Would you therefore propose a legislation, a parliament enactment, and not a court enactment to fill this gap? Or now that you're going to the policy court, where things are large, you would prefer that if Parliament is not acting, you will zoom in to act, bearing in mind the fact that after Klomega in Article 1815, where you give Parliament the chance to enact, to regulate. We are still not done with that. Would you want to take that up, should there be a situation like this, to fill the gap, my lord?
Thank you, Honorable Chairman. If the opportunity came my way, I do not think I would mind. However, Parliament could do same. Thank you.
My lady, I didn't get the last part of your question.
However,
your answer, please.
I said, however, Parliament could do same, but if I had the opportunity, I would do it. But
I'm sure the leader of government business has heard us, and the Children and Social Protection Minister has heard us to make proposal to the executive. If it comes, I'm sure it's something that Parliament could consider. Thank you very much for that view. Now, on social roles and constitutional evolution, some have argued that exclusive maternity leave reinforces outdated gender roles and that equal parental leave will promote shared caregiving. From a constitutional perspective, how should the law respond to such evolving social expectations?
thank you, Mr. Chairman. Did I hear equal paternity?
What I'm saying is that reinforces outdated gender roles, and that equal parental leave will promote shared caregiving. Now, from a constitutional perspective, you go into a constitutional court. How should the law respond to such evolving social expectations?
I think a question ago, Honorable Chair, a question ago, the answers would fit into this. If we are to go forward and apply equal leave on both the paternity and the maternity side, we have the maternity leave already. We should then bring about the paternal leave so that it is equal. Both parents can share. Thank you.
You are giving some good news to the men. Very well. Now let's also look at balancing biological realities with equality. On this score, I would want to pick your thoughts on this. So while childbirth is biologically tied to the woman, some say that postnatal care, biological differences with the constitutional imperative of gender equality.
Very well. Talking about postnatal biological duties. If I were a young mother, just had a baby, I do not think that I'll leave my baby with the father of the baby to breastfeed it. Thank you.
My lady, but these days we are told that there is this machine that pumps the breast milk. So, my lady, if you have to go and preside, and the man has taken paternity leave, maybe if you, within some 4 hours, maybe these days that you can sit in the afternoon, doing your case management, some 2 hours, and come back. Is it the case of my lady that you're going to straightly stay by baby girl? Is that the impression my lady is creating? Without maybe pumping for the man to take care of that within the 2 hours or 3?
Honorable Chair, thank you. My premise was if I was a fresh mother and had just had a baby, I do not think, if I had just had a baby, I don't think I'll be going to the courtroom soon, and I wouldn't like to leave my fresh baby with the daddy. If the baby were 9 months, I can
that's fine.
Express milk and put down and.
Very well. Okay. All right. Now then, let's deal with international human rights commitment a bit. Our country is a party to international human rights treaties that promote gender equality, such as the CEDAW. Should these international obligations influence judicial interpretation in favor of paternity leave? In view of all the thinking so far you've put out regarding your position on such rights?
Yes, why not? So long as they bring about good practice, but then we would have to marry them into our own experiences and come out with our laws that fall within what those rights are.
So, my lady, so looking at your date of birth, should the majority eventually confirm you, how many years are you going to be on the Supreme Court bench?
6.5 years. My Honorable Chair, 6.5 years.
My lady. Honorable Parliament will do the approval, and we are in the process of vetting. Why do you say should majority confirm you?
I get what the chairman is saying. What I'm suggesting is that normally we take decision by majority. You know, majority carries the vote. When they are yesterday's sins, I don't think. Anyway, yeah. You are a backbencher. When leaders are having their thing, you want to get yourself involved. You are just a returnee. Are you the avant-garde of government business? Only yesterday, you people had a different position.
Address the
now
chair
you have
and
changed.
proceed to ask your
Inconsistent
question.
people. Very well.
Proceed to ask your
Judicial
question.
role in gender justice. My lady, if a case challenging constitutionality of laws granting maternity leave but denying paternity leave come before you, how would you approach the issue to ensure fidelity to both equality and public interest?
I will look at the laws and apply what they say. And if there's something missing, and from the point of the facts before me, I can cure any mischief or lack, I'll do so according to law.
My lady, I'm now going to focus on issues on constitutional provisions relating to the Council of States, i.e. Article 89 to 92, and the growing public calls for its abolition or reform, especially proposals to replace it with a second chamber of parliament, i.e. a Senate or a House of Elders, to strengthen deliberative governance. So, my next set of questions are going to be based on these. So first would be on democratic legitimacy and constitutional design. Now, the law provides that the Council of State is an advisory body with no legislative power. Yet, it is sometimes called a toothless echo chamber. In your view, does its existence enhance or undermine democratic accountability and legitimacy within Ghana's constitutional framework?
Thank you, Honorable Chair. I'm not of the view that its existence undermines what you have just said. I'm of the view that if we find that they lack certain strengths, those could be enhanced to make their output serve our purposes as a nation. Thank you.
Now, my lady, in the advisory role, reference is often made to decisions that they have communicated to the presidency. And the decisions are communicated without the details being shared with the public. And the public lately seem to be so concerned about the governance of our country. Would you suggest that the time has come for the Council of State to be seen to be doing some interfacing by explaining to the public or sharing with institutions like Parliament some of its decisions? After all, even in the lawmaking process, where the president refuses to assent, there's a process that requires a referral to the Council of State for them to have an opinion and bring it back to Parliament for a second consideration of the bill. This, it is stated in the Constitution. But in other matters, we don't. A recent example is the public outcry regarding their determination of a prima facie against her ladyship, the Chief Justice. For instance, could have come out with their written opinion and share with the public on what constitutes the prima facie which led to the president exercising the discretion to suspend. That would have been helpful for governance. Would you be of that position that they should be seen to being proactive and sharing with us the views they express in advising presidential decisions or guiding presidential decisions? It could be anybody. Who knows?
Thank you, Honorable. There may be some things which right now here I cannot mention, which may be necessary for them to explain to the public, but I do not believe that in all things they have to come and explain to the public as an advisory body. Thank you.
Now, my lady, let's delve into comparative constitutional models. In other jurisdictions, upper houses or the Senate exist to provide mature second thought to legislative processes. Do you believe replacing Ghana's Council of State with a second chamber will better reflect the principles of representative democracy?
Honorable Chair, I do not think that will necessarily be so. Thank you.
You don't think?
My answer to the question was, I do not think that will necessarily be so. The replacement.
Very well. Can you explain? Can you justify?
Can I?
The upper houses or the Senate exist to provide mature second thought to legislative processes. Do you believe replacing Ghana's Council of State with a second chamber would better reflect the principles of representative democracy?
I said I necessarily, Honorable Chair, my answer is that I necessarily do not think that will be so, coming from my earlier answer that the Council of State could be strengthened. Thank you.
So now, let me follow up on the phrase could be strengthened. Can you share some views on ways of strengthening the Council of State to enable them meet modern expectations in governance?
Very well, Honorable Chair, thank you. I'll say that before this moment, this question had never come to me. If I am to give you a view, I'd have to sit down, critically look at the articles on the Council of State before I can come out. But I gave an example that in the advisory role, they may have to share certain things with the public, and not everything. That is one thing that could strengthen good governance. Thank you.
My lady, some have held this view that Article 89 appointment in part perhaps amount to elite capture. Reason ascribed to this include the fact that it allows the president to appoint majority of its members, and the president may exercise their discretion by perhaps yielding to some elite in society who would want to be there. Do you consider this concentration of appointment of power? There are regional reps. Each region brings a representation, and the mode of election comes from the various assembly members, the college, to do this election. But I am, the mainstay of my question is on the concentration of power in the hands of the president to choose majority. Do you think that this is a threat to the independence of the council, and the constitution must be looked at, in your view?
In my view, I do not believe that it's a threat. As you said, there's regional representation. That, in my view, is a balance. Thank you.
Arithmetic balance. Like I said, the majority looking at the issue of the majority being appointed by the president vis-a-vis the independence of SEMA. If, as it were, the regional representation would amount to, say, 55% or 60%, and the president's appointment is, say, 40%, like we have in a number of governing councils. Most of the university governing councils, they are up to like 17, 18, but the actual presidential appointment in them are 4, not more. So it's in that context that I want to pick your thoughts regarding whether the constitution can help.
This can help us, or if amended, because it is as it is.
Oh, yes, obviously, I'm looking at, when I say to be constitutionally addressed, I believe you appreciate
I am still of the opinion that I do not think that because you're saying that most of them are appointed by the president, that is.
My lady, given that the Council of State's advice is not binding and that Parliament already performs scrutiny functions, what would you say would be your views for the justification of the constitutional purpose of the Council of State?
Thank you, Mr. Chairman. Not too long ago, you asked whether there was a need to create an upper chamber or second one to help carry out the work of.
That will not just be advisory, but enhance
yes,
lawmaking.
So I am saying.
Honorable member, with all due respect, let me repeat. If a question is posed to the nominee and the nominee is in the process of answering the question, respectfully, let's allow the nominee to finish answering the question. Then you have the opportunity to ask another question.
Thank you, Mr. Chairman. I remember your question is, their advice is not binding. Is that it? However, I'm still asking the question. You are saying that the advice from Council of State is not binding.
However, Parliament, in the performance of its mandate of scrutiny, is able to undertake reviews and make laws. In that context, I'm trying to pick your thoughts as to whether or not there is still any constitutional relevance of the Council of State. However, you were trying to relate it to my earlier position on the need to create an upper chamber. And I was trying to draw your attention to the fact that the context I placed the upper chamber was to help enhance the process of lawmaking. They will not be there merely for advisory purpose. So I was trying to get that context captured properly so that it aids you in your answer.
Very well. Earlier on, I think I mentioned the Council of State should be strengthened to perform its duties. So I'm of the view that if now the advice is not binding, it is one of the things that could be looked at. Thank you.
Now, my lady, we have the Council of State, we have the Parliament, we have you, your institution, the courts. In your very honest opinion, do you think there are still very grave deficits in terms of the checks and balances on the executive arm of government?
I hope I understood the question when you say whether there are still very great deficits. Exactly what would that mean?
Well, what I mean by deficits or gaps in the checks and balances is to mean that we've had views expressing concern about the powers of the executive, and that it appears that the checkmating of the executive is not sufficient enough. For instance, in the situation we have now, where the ruling government is having 2/3 or almost in Parliament, the view is that the checkmating, the checks, will not be as expected because they would use their majority to protect government. Same way, when it was 137, 137, with that strong numbers, the executive background upon which I'm with all of these, legislature is there, you have the Council of State, including the judiciary. There are still some gaps to be filled. And of course, I know that CSOs are also doing their best. They whistleblow and all. In spite of all of these, Ghanaians seem to have serious concerns about the governance and the exercise of executive power. Do you think there are still gaps? And what, if so, do you have some suggestions to help strengthen these to ensure some safeguards?
In my humble view, Mr. Chair, I do not think that the gray gaps, or as mentioned by the honorable member, are any deep or many. As I can see, he himself is working very hard. And the judiciary is also there. And the checks and balances within the constraints or the ambit of the Constitution are working. Thank you.
My lady, you are an Article 71 office holder.
Respectfully so,
Right.
Mr. Chair.
So let me ask this. How do you reconcile the exclusive remuneration regime under Article 71 with Ghana's broader public sector pay policy, particularly the single spine salary structure? Would you suggest some amendment? Do you think that there must be some amendment to Article 71 in view of our public sector pay policy, which moves in a certain direction?
Very well. Thank you, Mr. Chairman. I would not suggest that there should be an amendment, but looking at the other side of the coin, where there's always a cry for better conditions, government should pay the other side better. Thank you.
The Constitutional Review Committee is doing some work. Of course, you as a judge, your job is also do your review while sitting on the bench. May I ask, should you eventually get to the bench, would you consider it within the judicial remit to interpret or limit the scope of Article 71 to reduce disparities in compensation across public institutions? And I say so based on your earlier answer that you believe that the others who are not covered by Article 71 should be well considered by government in terms of their remuneration. That they should be paid well. Those were your words.
Kindly, Mr. Chair, so what is the current question?
The current question is that, would you consider it within the judiciary's remit to interpret or limit the scope of Article 71 to reduce disparities in compensation across public institutions?
Thank you, Mr. Chairman. I believe this is another way of asking me the same question. At the end of the day, I said I did not agree that the Article 71 conditions should be subject to an amendment. The other side should be improved. So why would this happen now? No.
My lady, there are public concerns that Article 71 fosters self-serving pay increment by political elites, including other beneficiaries under 71. The judiciary cannot be taken out because you are expressly stated there. What constitutional or legal checks do you think should be imposed to prevent abuse and restore public trust? The concern has been that the committee, Mr. Bedzedek, you are not talking on record. Can you be quiet and listen?
Please.
And if you disagree,
Leader,
and if you disagree,
you are supposed to address the chair. You are supposed to address the chair. You are supposed to address the chair. So please go ahead and address the chair. Me, what I've heard is when you said abuse of Article 70, this thing rhetorically, the head, is it being abused? So this should not detract your attention from proceeding to answer the question that you have to. Yes. Your member do not even know what is happening. So just focus on your question.
my lady, this is part of politics. I'm used to it, so I'm used to it. One day they will be in this chair. One day, very soon. So let them enjoy the liberties of governance and intimidate me. I will get them. They would be
Let
here
me
in minority.
complete your prophecy by saying that after 50 years.
No problem. It's okay. We prophesied in 2016 that it would take you 50 years, and you are here. Don't worry. Don't worry. You would have to bring a new candidate in 28. We will see. You continue enjoying and intimidating. These are precedents that tomorrow, when you are suffering, you will have no ventilation. So enjoy what you think you are doing to me. You are returning. You are also talking some. I've forgiven you your sins. It's okay. Very well. It's okay. This is part of the politics, you know. My lady, it was just to give you some breather, so we come back. So, my lady, the question here is that there are public concerns that Article 71 fosters self-serving pay increment. Now, I want to know from you what constitutional or legal checks do you think should be imposed to prevent abuse and restore public trust? Because the public is always out against this Article 71, and I believe you hear these public outcries.
Very well. Very well, Mr. Chairman. As the Constitution stands and what provision it has made for Article 71, I believe it is within that ambit that when it is time for the emoluments or salaries or whatever underneath it to be paid, are paid. You were talking about political something earlier on, and you said judges are also there. I can only speak for judges. I will say, for good reason, the judiciary was placed under Article 71. And down the years, as compared to you were advocating for people on single spine, etc. I know others elsewhere who work and are paid single spine have their pay increments annually. It does not happen in the judiciary. We wait, as it were, 4 years passes, and we are paid those monies, which we should have been earning 4 years ago, 3 years ago, 2 years ago, 1 year ago. You and I know what happens to the economics of it. So in my view, I don't find that disbursement to the judiciary as abuse when the time comes for us to be entitled to what is our entitlement. Thank you.
My lady, it's the same thing for the political class, the MPs, the same thing. The ministers, the same thing. But it appears that the public doesn't see it in that light. It's a reason why I would follow up by asking whether you will agree that to bring certainty to this matter, if somebody on single spine receives an annual increment, there is a proper bargaining, whether minister, MP, judge, Public Services Commission chair, Judicial Council, Council of States, there must be a system that allows you to negotiate your wages, remuneration commission that determines year on year, so that you know that each year this is how it's going to be. Now, this thing is constitutionally guided, so you cannot touch it. In the spirit of ensuring certainty, would you suggest a judicial touch on this provision? In other words, amending Article 71, or that the Constitutional Review Committee should look at addressing this issue in Article 71.
Very well, thank you, Mr. Chairman. If the need arises that the Constitutional Review Committee has to look at it, I do not have a problem with that. If it has to come to the point where people will have to bargain, like you said, for their salaries or entitlements, for lack of a better word, like it's done, maybe single spine annually, like you're saying. I mean, in reality, who likes taking their salary 4 years back and it doesn't have economic value. Those are all issues that could be looked at. And if there's a real need, then something could be done about it. But like you yourself said, it is part of the Constitution for now.
So, Article 71 insulates certain public office holders from salary regulation under general law. And those public office holders we already know, we need not repeat. Do you think that this provision itself violates the spirit of equality and non-discrimination as enshrined in Article 17, given the fact that others would have to be on single spine?
Very well, Mr. Chairman, thank you. I am not comfortable with the word insulate. I do not think Article 71 was put into the Constitution to make anybody better off than anybody. The Constitution was promulgated by the people for the people to work for them at a certain point in time. And they thought it so. And we have it as it is. So if you say that it is discriminatory, I would not totally agree, because for good reason, Article 71 was put in the 1992 Constitution. Thank you.
My Lord, I'm now taking you through my last set of questions, and then we are done for the day. And please bear with me. I want us to deal with some theoretical and constitutional justifications, and then ask that, critics argue that the doctrine of adverse possession permits a trespasser to obtain legal title through unlawful occupation, undermining the constitutional right to property. In your view, how does the concept of adverse possession reconcile with Article 20 of the 1992 Constitution? Preservation of property.
Well, Mr. Chairman, adverse possession, we know does not just happen. Certain things happen that eventually end up in adverse possession. And if that does happen, and the law says the property passes on, I do not think how that is contradictory to what the Constitution is saying. People are not denied of owning property, but if you have property and you sit by idle, at the end of the day, you may lose it. Thank you.
So, my lady, it is your view that it does not run counter with Article 20 of the 1992 Constitution, which guarantees protection from deprivation of property?
That's my view.
Very well. That's okay. Now, I want to know, what's your considered view regarding the continued relevance of the doctrine of adverse possession in Ghana today, especially given the growing incidence of land disputes, poor record keeping, and customary land tenure complexities?
Hi, Mr. Chairman. Did you say what is the continuous worth of adverse possession?
relevance. We've had growing incidents of land disputes, poor record keeping, and customary law land tenure complexities.
Well. Thank you, Mr. Chairman. Adverse possession will always be adverse possession, and land disputes will always arise. At the end of the day, when parties find themselves in court, it's up to whoever to prove whether there's adverse possession or they are the owners of the land. Thank you.
My lady, can you readily share with us any case law which application of same has shaped the law on adverse possession? Do you readily? Very well. That's okay. My lady, so we would conclude on Article 33 of the Constitution, which guarantees enforceability of fundamental human rights in the context of sexual freedom, same-sex relationship, use of sex toys, and civil partnerships. I want to pick your thoughts on this. And I have put them together to explore your views on limits and evolution of constitutional rights, particularly in the light of Ghana's dual citizen era, international human rights standards, and the growing debate around sexual autonomy, morality, and legal progressiveness. Now, on constitutionality of sexual freedom, Article 33 allows court to enforce fundamental rights even if they are not expressly stated in the Constitution. In your view, can the right to sexual autonomy or sexual orientation be interpreted as an implied constitutional right under this provision?
Respectfully, let this cap pass away from me. I believe that the Supreme Court has made some pronouncements on, if I will put it this way, people with different sexual orientations. So I would not want to comment further.
My lady, just to bring clarity, my lady, is it your case that there's a Supreme Court decision on this very matter? If I understood you correct, because the rest of the questions will emanate from this area. So if you say...
you talked about sexual... The question mentioned something about sexual orientation. If I'm...
Let me put it again. Let me restate it. Is that okay? Can I...
Let me hear you again. If I can answer it, I will.
Very well. What I'm saying is that Article 33 allows courts to enforce fundamental rights even if they are not expressly stated in the Constitution. In your view, can the right to sexual autonomy or sexual orientation be interpreted as an implied constitutional right under this provision? In your view, can the right to sexual orientation or sexual autonomy be interpreted as an implied constitutional right under this provision?
If I understood the question, Honorable Chair, the same Article 33(1), in the middle of it, somewhere says, without prejudice to any action that is lawfully available. If that were to be the case, then I believe those rights. But if for now, certain sexual orientations are not legally on our books or accepted, then I do not think those things could be interpreted here, sexual autonomy, etc., etc. That's my view of it. Thank you.
Yeah. My lady, I am not going into statutes. I am veering into the Constitution. And saying that unless we have a disagreement of the position I've taken to the effect that Article 33 allows the court to enforce fundamental rights that are not expressly stated in the Constitution. First of all, do you agree with me on this position of the Constitution, that those that are not even expressly provided for, the courts are to provide for such rights under 33?
Very well. 33 says the person may apply to the court for redress. So I believe.
So in that context, I'm picking your thoughts as to how such rights can be interpreted as implied constitutional rights, because they are not expressly provided for. And you have agreed to the suggestion that, yes, the Constitution allows a human rights court in making a pronouncement in your own words that when you make the application for certain reliefs and it considers these as within your rights, it may grant that. I want to ask, under the same implied principle, can this be considered?
Thank you, Mr. Chairman. Honorable member, those were not my own words. I read from the Constitution. And at the end of the day,
I said very well. It doesn't call for your interview. I'm agreeing with her.
You see, leader, what I want us to do is that you don't gag the nominee. Once the nominee is ready to provide an answer, it is our responsibility to listen to the answer. You may be satisfied, but others are also here. So allow my lady to provide the answer. So, my lady, you have the floor.
Thank you, Honorable Chair. Yes, Mr. Chairman, the provision made reference to allows an applicant to come to court for rights which are not expressly stated there. Beyond that, what I'll say is that they may come to court. When that time comes, we'll cross that bridge. Thank you.
My lady, on the issue of, on this very score, let me further ask you, how, in your view, should the court respond to arguments that criminalize same-sex relationships and say that same is inconsistent with constitutional guarantees of equality, dignity, and non-discrimination?
Honorable Chair, at this watershed point, I have no opinion or comment on that. Thank you.
Now, my lady, we are in an era of global citizenship and legal duality. On the basis of this, I would want to find out from you that given that many Ghanaians hold dual nationality, live in countries where same-sex marriage and civil partnership are lawful, how should Ghanaian law adapt, if at all, to this evolving global reality?
Honorable Chair, as I've stated not too long ago, as I sit in this chair, I have no comment. Thank you.
My lady, may you turn to Article 66 of the Constitution? Yeah, I know, I heard it.
Well, leader, let me just remind you that a question has
I am
been asked
aware.
on Article
Yes, I'm aware.
66.
I am aware.
Yeah, just remind you.
No. I followed the entire proceedings from the office. So I am aware that my lady, in an earlier Article 66, the term limits, you added your voice to the many other views on this very matter, that the term limit as provided for in the Constitution needs no interpretation. It is what it is. Do you think that such views expressed by you today can change?
Respectfully, no, as I keep fidelity to the law, because that is what is written.
My lady, I shall thank you for indulging me and wish you well.
Thank you, Honorable Chair.
Thank you very much, honorable members and our revered guests, including the nominee. Well, I would give the floor to Honorable Roxanne Nelson Dapamokpo, limited to what he wants to say.
No.
So please, do. He's a member, he didn't ask a question for the whole day, so please.
Chairman, we are done. I've also seen Mr. Dekanyadi here, so if we all want to acknowledge people, I've also seen Mr. Dekanyadi. I know what he wants to do.
Oh.
I've also seen...
that's our big sister. You and I.
I know, but
so
Uncle Dick is also here.
Yeah, yes.
I know you to be very accommodating.
Yes. My lady, you are welcome and congratulations. We are very proud of you. The entire Peki and Southern, we are proud of you. Thank you. That's all. We wish you well.
Thank you. Calvary Methodist Church.
We've come to an end of the vetting of the nominee. Indulge me to acknowledge the revered guests seated behind her. First on my list is David Bartels-Kodwo, Esquire, husband of the nominee. Honorable guests in Parliament, we say here, here. We do not clap. Second on my list is His Excellency Jonathan Bartels-Kodwo, in-law. Emmanuel Bartels-Kodwo, Esquire, in-law. Eko Bartels-Kodwo, Esquire, son. Kukwa Bartels-Kodwo, daughter. Justice Novisi Ayene, colleague. Justice Cyril Krantin, colleague. Justice Efia Sawadazi, colleague. Sednam Awo Kwadam, colleague. His Worship Akosua Amu Godfred Jesse, colleague. Raphael Banagmen Esquire, friend. Richard Akpokavi Esquire, friend. Emmanuel Vincent Esquire, friend. Senior Dick Anyadwi Esquire, family member. Adam Minka Esquire, cousin. Iris Dovlo Esquire, cousin. Daniel Ado, friend. His Lordship, Justice Paul Bafobani, Acting Chief Justice. His Lordship, Justice Emmanuel Kulendis, Justice of the Kulendi, Justice of the Supreme Court. On behalf of the committee and on my own behalf, you are all welcome. And thank you very much for staying with us throughout the day and part of the night. My Lord Nominee, to you I say congratulations. You hear from the committee and you are accordingly discharged. Thank you very much.